I remembered the line from the Hindu scripture, the Bhagavad Gita. Vishnu is trying to persuade the prince that he should do his duty, and to impress him, takes on his multi-armed form and says, "Now I am become death, the destroyer of worlds."
Oh, how can this be? I finally found peace.
I've created a poll on Instagram and Facebook regarding this topic, and I saw how a lot of us are still in factions, in division, and in wrestling with the concepts involved in rape. And disclaimer, I'm not a professional in any way or a professor. I'm just a philosophy student who is sharing with you the lectures I have listened to and watched, and the readings I have read, mostly philosophical readings. The reading that I will be referencing to is A Most Detestable Crime by Keith Burgess, along with the philosophical professors and philosophers who will be contributing on the topic. I'm opening up a discussion on approaching the concepts in panggagahasa, especially in contextualizing it in the local setting. Being aware of the unique concepts that we have in our own language, like pambabastos, pagkatapak sa katauhan, pag-iingat, etc., and how it affects the interpretations that I will be sharing with you from the reading. So we'll be having an in-depth examination on the concept of rape and what falls under it, whether it may be consent, rape shield laws, marital exemption, gender neutral, etc. We will also be having a brief analysis on or examination on the Republic Act number 8353, or the anti-rape law in the Philippines. Be divided into three parts. The first part will be the history of rape law. The second part will be social revolution in the rape law and rape. And the third part will be the analysis of rape, philosophical analysis on rape, as well as a Philippine situation. The first question is, why do we have to understand the concept of rape? In the 1670s, a Chief Justice named Matthew Hale was known on his deliberation on rape as an accusation easily to be made and harder to be defended, though never so innocent. In retrospect, rapists fall under the category of pathology or deviance. Pathology being that the actor is considered as disturbed or deceived, and deviance being that the actor is considered as a bad man. Rape was also seen as an institution. Brown Miller in the book says that rape is nothing more or less than a process of intimidation, particularly by men. So this becomes a process of keeping women in a state of fear, thus becoming an institution. So this is what we know of as patriarchy, or the dominance of men in society. The first rape law was said to appear in 1900s BC in Babylon, or in the Code of Hammurabi. This particular law prohibited sexual intercourse with another betrothed wife, and this was considered a capital offense. But take note, there's this predominance in the occurrence of women being raped. This kind of presupposes that one's own wife can be raped, or what we can technically label as marital rape. The ancient Greek law was actually more gender neutral than the previous ones because it penalizes a rape of a man or a woman by severe punishments or fines. This is actually no surprise for Greeks because Plato, as an example, was an early advocate of gender equality, allowing women to participate in the big roles in the society or in the polis. Weirdly though, seduction was considered more serious than rape by the Greeks before because seduction affected an individual's loyalty or feelings. Back then, it was a threat to a woman's husband, father, or guardian. In the latter part of this law, the wrong party was still dominantly male. No wonder why this family relation thing continued on for centuries ahead, such as in Jewish or Hebrew law. In a passage from the book of Deuteronomy, chapter 22, verse 25, "But if out in the country a man happens to meet a young woman pledged to be married and rapes her, only the man who has done this shall die." In Jewish or Hebrew law, there was a distinction between married and unmarried rapes, wherein those who inflicted married individuals were punished more severely compared to those that inflicted unmarried individuals. For instance, when a Jewish woman is married and she gets raped, that act is punishable by death. However, in unmarried Jewish individuals or women, it is required by law that the actor and the victim be married together. Ancient Judaism rape was not considered as a moral offense at that time, but rather a civil wrong, which is theoretically less heavy than that of morally assessing it. Such Judaism rape, it was a marriage market. That's why it is a civil wrong, wherein rape occurs whenever the virginity of a woman gets taken from its rightful owner, who is the father. The term rape was derived from the Latin word raptus. This was done through carrying off of a woman by force even without the presence of sexual intercourse. In layman's term, it is known as kidnapping or abduction. So raptors technically cause injuries to the household rather than injuries to the victims. This is seen as an offense against family rather than an offense against sexual integrity or bodily integrity, or other moral assessments at that. In the development of Roman civil law, from being a family offense, rape became a sexual offense. In this development, punishment to women who consented to being abducted was tantamount to their raptors. So, on the grounds that it could have been prevented had they not consented. But of course, this poses a lot of philosophical questions, like, what is consent? What constitutes consent? Roman law features two delimitations that could be shocking to modern individuals. Number one, it is impossible for a man to rape a prostitute. Number two, a husband can actually rape his wife. Rape, prior to 11th and 12th centuries, was seen as an offense against property. In medieval canon law, rape was also seen as force and seduction as promise. In here, four elements of the emergence of rape are made. Number one, the use or presence of violence. Number two, abduction. Number three, sexual intercourse. Number four, lack of free consent. So what else was in the canon law? The canon law actually insists that crying out was necessary as a proof of consent or the lack of it, while physical resistance was not really required. Canon law holds that it is through marriage that a rapist can be saved from punishment or severe fines or death penalty. But that is medieval ages ago, so no. In contrast to Roman law, English law provides or conceives it valid for a prostitute to be raped on grounds that a prostitute may have retreated or turned away from the lifestyle they took. It is because prostitutes back then were conceived as having an unlawful course of life. Sex workers' rights are also human rights. Prostitutes may have been conceived internationally as unlawful and even incompatible with the provisions of the human rights, but I do find it valid for its decriminalization on grounds of consensual sex and for a policy to protect sex workers' rights. This is so discriminatory because prostitutes or being a prostitute doesn't justify or doesn't give you a ticket to abuse them. They're humans and they're subject to moral assessment. The provisions provided by the Model Penal Code in Section 213.1 are similar to those concepts that were also involved in the previous laws, such as by force or by threat, serious bodily injury, abduction, impairment of control via intoxicants, unconsciousness, and finally age limit. Usually those that are aged 10 years old and below. In our summary of the history of rape law, we noticed that the rape laws provided were rather individualized compared to it being collective. So there's a conception of rape being an individual experience rather than a collective experience. There was also a shift from conservatism to liberalism and radicalism. So again, rape was perceived to be an offense against an individual, usually but not always a woman, rather than an offense against a community or society in general. Finally, quoting from Brown Miller in the book, rape harms women not just as individuals, but rather as women collectively. So in the next part of our discussion, we will now finally be analyzing rape through the help of philosophical essays that I will be sharing with you in The Most Detestable Crime by Keith Burgess, along with his contributors. So also you might want to check that out because it's important for us to read more about it if you want to. So be informed, stay healthy. Bye.